Mesdames,
Ladies and gentlemen, we will now open our 2674th meeting, 2654th meeting of our committee. And before I do anything else, on behalf of our committee, the United Nations Committee on the Elimination of Racial Discrimination throughout the world, today we have the honor and at the same time the opportunity to welcome, in fact, to give an exceedingly warm welcome to the representatives of the People's Republic of China. So we have the responsibility of receiving representatives of the People's Republic of China, members of the UN Security Council, internationally recognized in its national territory. And I would like to congratulate the honorable delegation of the People's Republic of China who have submitted their report on the subject of racial discrimination. And therefore, I would like to congratulate the People's Republic of China for the honor they bestow on this committee by being here in Geneva with one of the most important delegations that this committee has hosted. So the honor for our committee is such that all members of the committee are indeed honoring us by their presence. Ambassador, I would also like to say that our meeting today is being webcast by the United Nations. So right now, as I address you, the whole world is listening to our meeting between China and the members of the committee. The head of the delegation, as head of the delegation, I would like to tell you that the honor that you bestow on this committee is considered to be recognition of the work of the committee. And once again, thank you. With your permission, sir, I would like to explain how we will proceed, how our meeting will be organized today until 6 p.m. and on Monday between 10 a.m. and 1 p.m. So, head of delegation, you will have 1.5 hours given the importance of the issues raised in order to address the committee with a spoken statement which will be considered an additional element to the written report itself provided by China. And then we will listen to Mr. Marogan, the rapporteur for China, the Honorable Mr. Marogan, the rapporteur for China, who will provide an evaluation of the issue of racial discrimination. Ambassador, Mr. Marogan's statement will be followed by Mr. Kut, who is responsible for follow-up to the conclusions, the final conclusions of our committee, and therefore he will talk about the current situation just after the rapporteur has finished his statement. Once Mr. Kut has spoken, then we will have questions from the other members of our committee. Those other members will make observations on the issues relating to our convention. And if the issues raised can be answered on a preliminary basis, that is to say, the questions raised by the rapporteur, Mr. Marogan, and the other members of the committee. If the delegation is able to provide preliminary responses to some of the questions, then that is one alternative. A second alternative would be to invite the delegation to provide answers to the rapporteur or the members of the committee at 10 a.m. on Monday, because the delegation will have enough time to provide the answers to the questions asked by the rapporteur and members of the committee. And then if the delegation does not answer all the questions because of lack of time, then the delegation will be invited to provide written answers so that 48 hours later, Mr. Marugan will take note of the written answers so that he can recommend conclusions to the committee which can be amended if necessary by the members of the committee in a closed meeting. Therefore, Ambassador, Head of Delegation, I will now give you the floor so that for 1 hour, 30 minutes, you can address the committee. I will give you the floor, sir.
Mr. Chairman, respected Mr. Rapporteur, Ms. Co-Rapporteur, members, ladies and gentlemen, good afternoon. At the outset, on behalf of the Chinese delegation, I wish to extend sincere greetings and pay tribute to the members. The committee has done a lot of work to promote the realization of the purposes and principles of the convention. The Chinese government appreciates your contribution and will, as always, support your work. Today, my colleagues and I in the Chinese delegation have great pleasure to present the combined 14th to 17th periodic reports of China on its implementation of the ICED. The delegation is composed of 48 officials and experts from 32 departments in the central government and in the governments of 2 special administrative regions of Hong Kong and Macau. Among them, 8 colleagues are from Tibetan, Uyghur, Yao, Korea, Hui, bi-ethnic groups. The delegation will take an open, cooperative and responsible approach to the dialogue with members to assist you in a comprehensive and objective understanding of China's implementation of the convention. We also welcome your constructive comments and recommendations. Mr. Chairman, members of the committee is reviewing the period since 2009 when China made tremendous progress in all areas, and the country entered into a new era of development. In this context, and in addition to our reports, I wish to update you on our work in recent years on ethnic affairs and on the protection of the rights of ethnic minorities. My colleagues next Monday will answer questions from members and give details, including data. Firstly, a strong sense of community for the Chinese nation has become the guiding thought for the ethnic cause in the new era. China is a unified multi-ethnic state. Han and 55 other ethnic groups make up the Chinese nation. In the continuous development of the ethnic cause in recent years, the population has further accepted the notion of the community of the Chinese nation, that is, the Han Chinese cannot live without ethnic minorities and vice versa, and no one ethnic minority group can live without other ethnic minority groups. In his report to the 19th CPC Congress in October 2017, General Secretary Xi Jinping explicitly called for a strong sense of community for the Chinese nation as the guiding thought for the ethnic cause in the new era. The amendment to the Constitution adopted in March 2018 changed the wording from upholds and develops a relationship of equality, unity, and mutual assistance among all of China's ethnic groups to read upholds and develop a relationship of equality, unity, mutual assistance, and harmony among all of China's ethnic groups. This reflects more fully and accurately the essential feature of our ethnic policy. The most fundamental element is the steadfast implementation of ethnic equality, enhancement of ethnic unity, and promotion of inter-ethnic mutual assistance and harmony, so that all ethnic groups work together as one large family for common prosperity and development, and for realizing the Chinese dream of a great rejuvenation of the Chinese nation. Secondly, the legal system for ethnic affairs continues to improve. Human rights cannot be protected without legal guarantees. As stated in our reports, China continues to steadfastly develop its system of regional ethnic autonomy. The ethnic legal framework is based on the Constitution, supplemented by the law on regional national autonomy. Since 2012, the government has actively promoted a strategy of law-based governance across the board. A new situation has emerged where legal thinking and the rule of law have become the means to promote the development of ethnic groups and protect the legitimate rights and interests of people of all ethnic groups. Laws and administrative regulations have been enacted and amended, over 20 of them, including the tourism law, the public cultural service guarantee law, the law on Chinese traditional medicine, and on religious affairs, providing for prohibition of ethnic discrimination or hatred, promotion of ethnic equality, enhancement of inter-ethnic unity, and a guarantee for all rights, including freedom of religious belief. Autonomous ethnic regions have enacted or amended over 20 regulations on the exercise of autonomy and over 200 separate regulations covering political, economic, social, cultural, and educational fields and ecological presentation, thus refining the system of laws on ethnic affairs. Ethnic minority cadres play an important role in ethnic rule of governance. For example, 5 months ago, the NPC, the Supreme State Authority, held its 13th session with 438 delegates from ethnic minorities, reaching 14.7%. Higher than the proportion of ethnic minorities in the overall population. Among members of this Chinese delegation here, Mr. Cassel, ethnic Uyghur, is a delegate to the 13th NPC. Thirdly, promote vigorously comprehensive development in ethnic areas. The committee in its last review also highlighted the underdevelopment in ethnic areas. In recent years, the government made great efforts to bridge the gap between ethnic areas and other developed areas. A series of policy and plans were made. The 13th Five-Year Plan for Economic and Social Development 2016 to 2020 has chapters on promotion of healthy development of ethnic areas and the development and opening up of border regions. The 13th Five-Year Plan on the promotion of development in ethnic areas and small population ethnic groups. The 13th Five-Year Plan on revitalizing border areas and enriching residents' lives. They cover progresses in economic, social, health, educational, cultural, environmental conservation fields, resulting in rising levels of all human rights enjoyed by ethnic minorities. In ethnic areas, the economy has made significant progress. and the people's living standard continues to improve. In 2017, 8 ethnic provinces and regions, that is 5 autonomous regions including Inner Mongolia, Guangxi, Tibet, Ningxia, Xinjiang, and 3 multi-ethnic provinces including Guizhou, Yunnan, Qinghai, reached the total output value of 8,873 billion yuan, that is 1,344.4 billion USD, 7.6 more than 2016 and 0.7% higher than the national level. The per capita disposable income of urban and rural residents reached respectively 4,781 USD and 1,582 USD, the increase respectively of 8.4% and 9.2%. The population in poverty went down from 31.21 million in 2012 to 10.32 million, and the poverty rate from 34.1% to 6.8%. In a short period of 5 years, in these 8 provinces and autonomous regions with poor economic and geographical conditions, over 20 million people were lifted out of poverty. An extraordinary achievement indeed. I wish here to tell you a story about targeted poverty alleviation in China, a basic policy originating from supporting ethnic minorities. In the remote mountains of Hunan province situates a Shibadong village of all ethnic male people. It's a typical poor village with shortages in land, technology, and funding. In November 2013, General Secretary Xi Jinping, during a field visit to the village, proposed for the first time the guidelines of targeted poverty alleviation, namely proceed practically from local conditions and give tailored guidance to different types of cases. Guided by these principles, the village conducted targeted poverty alleviation based on local conditions and characteristics of the population. A number of pillar industries took shape, including fruit plantation, handicraft, cultural tourism, significantly boosting people's income. In February 2017, the village was lifted out of poverty, the first in Hunan province. The story was made into a film entitled, in English, Hold Your Hands. We have brought here the DVD to share with members. Supported by economic growth, progresses were made in health, education, cultural, and ecological preservation. In addition to details in our reports, I wish to add the following on protecting the cultural of ethnic minorities and their ecosystems. The government has always attached importance to protecting and carrying forward the culture of ethnic minorities, which is an integral part of the Chinese culture. A tangible heritage is villages with ethnic characteristics. For example, the Pengjia village in Hubei province. The village consists of some 250 Tujia people in 48 households. The traditional architecture built towards the end of the Qing dynasty, including Diaojiaolou, a type of housing built on copper columns, is kept intact. A few years ago, the village was in a dilapidated state, worn down by ages of disrepair. Under the SEAC program for protecting and developing ethnic minority villages with unique characteristics, the village underwent protective repair with a view to restoring the old as it was. As a diamond, the village has become a tourist attraction. As ecological barriers and zones of headwaters, ethnic areas are key to building a beautiful China. Clear waters and lush mountains are invaluable assets. A policy of green development is pursued in ethnic areas. As against treatment after pollution approach, a case in point is the white paper published by the State Council Information Office last month entitled Ecological Progress on the Qinghai-Tibet Plateau. Located in southwest China, the plateau is the roof of the world, the third pole, and the water tower of Asia. The plateau is an important ecological security barrier for China and the rest of Asia. The white paper contains details of measures taken by the government, including enhancing legislation, increasing funding, expanding R&D and application, establishing a system of natural reserves and eco compensation, as well as preservation and improving the environment on the platform. China has adopted the above policies and measures by taking into account of its obligations under the Convention and its national conditions, as well as the useful recommendations contained in the concluding observations of the committee in the last review. Mr. Chairman, distinguished members, due to their geographic restraints and weak economic basis, some ethnic areas are still lagging behind developed regions in China in terms of economic and social progress. China is at a crucial stage of poverty alleviation. It needs to further address livelihood issues like health and education and better protect the ecosystem. In order to further develop and improve the legal framework governing ethnic autonomy, it needs to further implement the policies and laws aiming at protecting and promoting equality and solidarity among ethnic groups. During the larger process of national development, the Chinese government will continue to act in accordance with the Convention by adopting more effective measures to speed up all-rounded development of ethnic areas and areas inhabited by ethnic minorities, and continue to raise the level of human rights enjoyment by ethnic minorities. The implementation of the Convention will contribute to realizing the Chinese dream through the united effort of all ethnic groups. In this regard, we are ready to enhance cooperation and exchanges with the committee. Mr. Chairman, distinguished members, the Convention applies equally to the Hong Kong SAR and the Macau SAR of China. In accordance with the principle of one country, two systems, the governments of the two SARs prepare their respective reports on implementation. Now I'd like to invite Mr. Chen Shuifu from Hong Kong SAR and Mr. Liu Dexue from Macau SAR to present their respective reports. Thank you, Mr. Chairman and distinguished members.
主席先生
Mr. Chair, committee members, I would like to report the implementation of the International Convention on the elimination of all forms of racial discrimination in the Hong Kong Special Administrative Region since the last hearing in 2009. At present, there are some 250,000 ethnic minorities, or EMs in short, in Hong Kong. The Hong Kong SAR is committed to meeting our obligations under the Convention. We have been taking measures to reinforce protection of individuals against racial discrimination, to provide EMs with equal opportunities, and facilitate their integration into our community. Some EMs have encountered difficulties in adaptation and social integration due to language and cultural differences. To enhance collaboration within the Hong Kong SAR government on support for EMs in need, a steering committee chaired by the Chief Secretary for Administration has been set up in 2018 to coordinate, review, and monitor support for EMs in Hong Kong. and a sum of $500 million has been earmarked in the 2018-19 budget to strengthen the support services. On education, the Hong Kong SAR government is committed to encouraging and supporting the integration of EM students into the community, including facilitating the early adaptation to local education system and mastery of the Chinese language. At the last hearing, the committee expressed the concern that teaching Chinese as a second language for non-Chinese speaking, or NCS in short, students with an immigrant background was not adopted as an official education policy in Hong Kong. In this regard, the Education Bureau, in consultation with teachers and language experts, has been implementing the Chinese language curriculum second language learning framework in primary and secondary schools since the 2014-15 school year. The learning framework, which is designed from the perspective of second language learners, aims to help NCS students overcome the difficulties in learning Chinese as a second language, with a view to facilitating their effective learning of Chinese and bridging over to mainstream Chinese language classes as early as possible, and providing them with more opportunities to pursue further studies and career. Starting from the 2014-15 school year, the Education Bureau has been significantly increased the additional funding to schools to over $200 million per year at present to facilitate their implementation of the learning framework and the creation of an inclusive learning environment in schools. In addition, the Education Bureau will continue to set up school-based professional support services and professional development programs for teachers through diversified modes. At the same time, the Education Bureau has been reviewing the implementation of the learning framework and further enhances the teaching strategies, assessment tools, and supporting resources for schools as appropriate in a timely manner in the light of the views from various stakeholders and school practices on learning and teaching. On employment, we attach great importance to providing EMs with equal opportunities in seeking employment. As a largest employer in Hong Kong, the government plays an active role in ensuring that the Chinese language proficiency requirements for all civil service positions are commensurate with their job requirements so that all applicants have equal access to job opportunities in the government. In addition, the Labor Department provides dedicated employment services to EM job seekers and actively promotes their working abilities among employers. The Employees Retraining Board also provides dedicated training courses and support services to meet the career aspirations and training needs of EMs. At the last hearing, the committee expressed a concern over the conditions of employment of foreign domestic helpers, the 2-week rule whereby FDHs have to leave Hong Kong within 2 weeks upon termination of contract, as well as the living requirement, i.e. all FDHs are required to work and reside in their employer's residence as stated in the standard employment contract. Under our labor laws, FDHs enjoy the same employment rights and protection as local workers in relation to their entitlement to weekly rest days, paid statutory holidays, paid annual leave, sickness allowance, maternity protection, severance payment, and long service payment, etc. In addition, FDHs are further protected through the Hong Kong SAR government-prescribed standard employment contract, under which they enjoy the minimum allowable wage, free accommodation, free food or food allowance, free medical care, and free passage to/from their places of origin. The aforementioned benefits are not necessarily available to local workers. As for working hours, there is currently no legislation related to working hours in Hong Kong, and FDHs enjoy the same rights as local workers under the labor laws concerning rest days and other holidays. The 2-week rule is necessary for maintaining effective immigration control and helps prevent FDHs from job hopping frequently and working illegally in Hong Kong after premature contract termination. It does not preclude FDHs from applying to work in Hong Kong again after returning to their places of origin. The living requirement forms the cornerstone of the Hong Kong SAR's policy of importing FDHs. It has been our established policy that in many other jurisdictions in the world, priority in employment should be given to the local workforce. And importation of workers should only be allowed where there is confirmed manpower shortage in a particular trade that cannot be filled by local workers. In accordance with this principle, FDHs have been imported since the early 1970s to meet the shortfall of local living domestic workers. Given that there is no shortage in supply of local non-living domestic workers, any change to the living requirement will go against the rationale for importing FDHs and the fundamental policy that local workers should enjoy priority in employment. We will continue to strengthen the protection of FDHs. In March 2018, a high-level inter-bureau departmental steering committee with the Chief Secretary for Administration as its chair promulgated the action plan to tackle trafficking persons and to enhance protection of foreign domestic helpers in Hong Kong, to provide steer to the work of the Hong Kong SAR government in this respect. We have been operating the unified screening mechanism since March 2014 to screen non-refoulement claims on all applicable grounds. Procedures for the unified screening mechanism meet high standards of fairness required by law, including the provision of publicly funded legal assistance, as well as interpretation and translation services to all claimants. Claimants aggrieved by the Immigration Department's decision may lodge an appeal with the Impartial Appeal Board. The estimated expenditure on the screening of non-refoulement claims, including expenditure on various support services provided to the claimants, is about $1.4 billion in 2018 to 19, which represents an increase of 159% over that of 2014 to 15. We believe that public education and support services are crucial to facilitate better integration of EMs into the community. For many years, we have implemented an array of measures to promote racial harmony and facilitate the integration of EMs into the community. The Home Affairs Department renders dedicated services and programs for them through district networks, including commissioning non-governmental organizations to operate 6 support services centers and 2 sub-centers for them to provide various tailor-made learning classes, integration activities, and counseling services. Funding 2 community support teams, i.e. the Nepalese community support team and a Pakistani community support team, to offer integration services through members of their own communities, and launching district-based integration programs and the ethnic minority ambassador schemes. Furthermore, the Committee on the Promotion of Racial Harmony continues to advise the government on matters relating to fostering racial harmony and facilitating the use of public service by EMs. The Ethnic Minorities Forum also provides a channel of communication between the government and EM communities and the organizations dedicated to serving them. On legislation, the Hong Kong SAR government is actively following up on the Discrimination Law Review report submitted by the Equal Opportunities Commission, EOC, in 2016, and will put forward proposals to the Legislative Council within this year. We will take forward 8 recommendations of higher priority, of which 6 are related to the Race Discrimination Ordinance, such as expanding the scope of protection from racial discrimination from a person's near relative, like spouse and children, to associate, such as a career, such as a carer or a colleague, and prohibiting discrimination by imputation that a person is of a particular racial group. Mr. Chairman, distinguished members, The Hong Kong SAR government seeks to provide EMs with equal opportunities through enhancing legislation as well as education, employment and training, community participation and other support services so that they can fully integrate into Hong Kong, realize their potential and contribute to Hong Kong's success. Over the years, we have taken steps to promote racial harmony and equality. We will continue to make our best endeavor in this regard. Thank you.
Honourable Chairperson of the Committee, distinguished members of the Committee, to start with, I'm really deeply honoured to address this Committee and its distinguished members on the behalf of the Government of Macau Special Administrative Region of the People's Republic of China and to highlight the progress achieved since the consideration of our last report. The Macau SAR Government is grateful to the work of the Committee and has taken due consideration of its concluding observations and recommendations. I take this occasion to stress that the Macau SAR Government attaches great importance to the principles and rights enshrined in the Convention and being committed to ensure its implementation. All persons within the Macau SAR and subject to its jurisdiction are equal before the law, irrespective of their nationality, descent, race, sex, language, religion, political views, ideological belief, educational level, and economic status and social conditions. This cornerstone principle is part of the human rights legal framework of the region and expressly stipulated in the Basic Law. That is the fundamental law of the Macau SAR. The core fundamental rights and freedoms are guaranteed to residents under the Basic Law and are also enjoyed by other persons and shall not be restricted unless as prescribed by the law. The rights to equality and non-discrimination are enshrined in the Macau SAR legal system by a diversity of sources and at various layers of the normative system, from constitutional provisions to relevant applicable international treaties and to the ordinary law. Both principles find expression in the double meanings that everyone is equal before the law and through the law. It also encompasses the prohibition of illegal subjective indiscrimination and constitutes a guiding structure at the administrative, legislative and judicial levels, while requiring a distinct treatment of different situations when it is objectively justified and measured. Accordingly, positive discrimination is only admissible under the law as required measures to correct de facto inequalities. These guiding principles frame the Macau SAR legal system, in particular at the criminal level. As such, incitement to genocide, an agreement to commit genocide, and incitement to racial, ethnic and religious discrimination, defamation and slander are criminal offences. Homicide motivated by racial, religious and political hatred is qualified as aggravated homicide. Associations, advertisements and media advocating or encouraging the commitment of crimes on promoting intolerance, violence and hatred and inciting totalitarian behavior or aggression towards social, racial or religious minorities are strictly forbidden. Macau has a high population density with around 650,000 inhabitants, of which 170,000 are non-resident workers in an area of 30.5 square kilometers and more than 30 million visitors annually. Macau is a city of tourism and culture, embraces the value of tolerance and respect for cultural diversity, which are the keystones of the Macau SAR lifestyle. Indeed, Macau is a place where various communities live together with a wide range of ethnic, religious, linguistic and cultural backgrounds. Every ethnic group shares the same dignity and is entitled to its own cultural life, to practice its own religion and to use its own language. As such, the Macau SAR government embraces and promotes different cultural manifestations of the local communities. Progress has been achieved in the human rights field at the legislative and institutional levels, inter alia to establish a labor creditors' protection system to improve labor relations and non-resident workers' working conditions. Currently, the law on fiscal benefits for hiring persons with disabilities is being discussed at the Legislative Assembly. The public consultation mechanism for government policies and future legislation is also an important tool to engage the population in public affairs, including different ethnic and minority groups. Some key legislation, such as the law to counter human trafficking, to counter domestic violence and labor relations, have been translated into English and made available online. In In relation to the existing situations addressing human rights, the Commissioner Against Corruption accumulates the Ombudsman's functions to promote and protect rights and freedoms, to safeguard interests of individuals, to ensure that the exercise of public powers abide by the criminal justice, legality and efficiency. The Ombudsman's supervision powers have been gradually reinforced. The Commissioner can directly propose to the Chief Executive the enactment of normative acts and suggestions concerning their interpretation, amendment and repeal and many conduct inquiries, and especially regarding acts challenging the exercise of human rights as well as redress measures. It should be noted that the Commissioner is appointed by the head of the region and is bound by the Basic Law and by Law 10/2000 to exercise his ombudsman functions with total independence. Adequate financial and human resources are provided to guarantee strict independence and autonomy. And in this respect, it should be noted that equality before the law, the right to resort to the law, access to the courts and to judicial remedies are fundamental rights guaranteed under the law. Access to the law includes the access to legal information, legal protection and legal consultation and legal aid. This protection of rights and legally protected interests and the respective judicial remedies may not be denied on any discriminatory grounds, nor on the grounds of insufficient economic resources. The revised legal aid law clearly states that any person staying in Macau SAR with insufficient financial capacity, including non-resident workers, holders of refugee status and holders of special permits such as foreign students, are entitled to legal aid. Education, awareness campaigns and legal dissemination are other important components to ensure, promote and encourage universal respect for and observance of human rights and fundamental freedoms for all, without distinction as to race, sex, language and religion. Considerable efforts have been striven to widely and comprehensively promote and disseminate human rights, including the core human rights treaties, related reports and concluding observations and relevant laws, through modern means and actions, including new technologies in Chinese, Portuguese and other languages, especially English. In addition, substantive and effective measures have been adopted to promote adequate education on issues of gender equality, respect for persons' dignity, religious tolerance and anti-bias, and particularly through school circular public awareness campaigns and special training courses for officials, traditional teaching staff and different community source sectors. Within the context of the convention, it is also noteworthy to state that gender equality is the name of the SAR government. In religion, women share the same political, civil, economic and social, educational, cultural rights as men. In June 2017, female population accounted for 66.8% of the total labor force and 48.8% of all high-ranking positions in the special SAR. The second most important position of the SAR government, the Secretary for Administration and Justice, has been a lady since the establishment of the Macau SAR. Notwithstanding the gender equality principle, the de facto inequality still exists mainly due to cultural factors. The Macau SAR government continues in its efforts to foster gender equality in workplace, especially regarding working conditions and equal pay for equal work. The proportion of men and women in top positions is more symmetrical in skilled jobs. However, there are still gaps between their salaries, with more incidence on more economic activities and unskilled jobs. As regards non-resident workers, it should be emphasized that the SAR government has a non-discriminatory labor policy. The non-resident workers enjoy the same working conditions, labor rights and duties and guarantees as resident workers. The SAR government has been strengthening supervision and protection of non-resident workers' rights against abuse and exploitation. Multiple strategies to enhance workers' knowledge of labor legislation and their rights, to develop and ensure harmonious labor relations, such as counseling on labor legislation, 24-hour hotline for labor issues, email inquiry system, leaflets, talks, awareness campaigns in different languages have been adopted. Last but not least, with respect to refugees, there were only a few applications. Due to the procedure, applicants are entitled to basic living conditions, special support like medical services, schools for minors, to extend the application to include spouses and children and other family members, to interpreters, to legal protection, to confidentiality, to free legal consultation, and to contact the office of the UN High Commissioner for Refugees. Honourable Chairperson of the Committee and distinguished members of the Committee, the Macau Macau SAR government has endeavored to promote and ensure the enjoyment of fundamental rights and freedoms and equal legal protection without any form of discrimination. This is an ongoing task carried out by the government. Finally, the Macau SAR government will continue to improve and promote its work on the elimination of racial discrimination and to fully commit to ensure the implementation of the convention in the region. Thank you very much.
I would like to thank you for these three presentations. It is clear, as I said before, that the two others on Macau and Hong Kong will be considered to be integral parts of the report submitted to the committee. Thus, your statements, together with the report, constitute the full presentation to the committee. Having said that, Mr. Marugan, I would like to give you the floor now to present your report on the status of the question before us today. Mr. Marugan, you have the floor. You will have between 30 and 40 minutes to do this, given the substantial questions in front of us. So this is the time allocated to you, Mr. Marugan. Thank you very much. You have the floor, sir.
Thanks so much, Chair, for giving me the floor. Good afternoon. I would like to start by warmly welcoming the Chinese delegation. Thanks for your words, Head of Delegation, and the other representatives from the Hong Kong and Macau SAR. Thanks for sending us the report prepared by the central government of China, the report prepared by the Hong Kong SAR, and the report prepared by the Macau SAR of China. I would also like to emphasize, and I'm sure I speak in the name of the whole committee, if I say how grateful we are to China for proposing to be elected to serve to our committee a committed person like Ms. Li is. She is helping us a lot in the fight against racial discrimination. She is my neighbor in the committee. We have collaborated a lot, and I have a very high esteem of her. So thank you, Ms. Li, and thank you, China, for proposing her. I would also like to thank the civil society organizations. They have been very active, sending us reports, giving us information, and I thank them for their great help. Last time the committee had a dialogue with China was in 2009. The state report was due in January 2013, and we received the report on 24th of January of 2017. 3 years of delay. I would like to encourage you for next time to send it earlier. The report states that mainly concerns the progress made by China in its implementation of the convention from 2008 to 2015. We are in 2018, so we need to keep that in mind when we talk about the report, and also for the need for updated data. I'm going to start raising different issues, not exhaustively, and I'm sure that my colleagues will deepen on them and raise other ones. Ms. Gay McDougall and Ms. Vereen Shepherd, as co-rapporteurs, will be taking the floor after me on issues related to education, Ms. Vereen Shepherd, and to civil and political rights of Uyghurs, Ms. Gay McDougall. As stated in the Common Core document, China is the world's most populous country. China represents roughly 21% of the overall population of the world. Having this in mind, there are so many issues. We have received a lot of information. There are so many details. I think a dialogue with a state party representing about 20% of the population of the world should be done in more than 6 hours of dialogue, but we'll try. I understand we need to start by recognizing some positive developments and policies that have happened or have been approved and implemented in China. And you have talked about some of them, Head of Delegation. Over the past 30, 40 years, China has created extraordinary prosperity and has lifted hundreds of millions of people out of poverty. Figures from official institutions and from the World Bank range between 500 million and 767 million people that have been lifted out of poverty. And I think this is not only an important fact for China, it is for the world. This is a great achievement, and I would like to congratulate those responsible. And as we will see, it affects our mandate. I understand that for the Chinese government, poverty is the biggest obstacle to development and hence to human rights. I think we need to also congratulate China to what is stated in paragraphs 19, 20, and 28 of the States Party report, and you were reading it, Mr. Head of Delegation, saying that since 2008, the 5 autonomous regions of Inner Mongolia, Guangxi, Tibet, Ningxia, and Xinjiang, and the 3, and forgive me for my pronunciation, and the 3 multi-ethnic provinces of Guizhou, Yunnan, and Qinghai, hereafter referred to as the 8 multi-ethnic provinces and regions, have enjoyed gradual improvement in the quality of life of their populations. The Committee on the 2009 concluding observations noted with appreciation the rate of economic development, including the autonomous provinces largely inhabited by ethnic minorities. According to paragraph 28 of the State Party report, from 2011 to 2015, the poor population of the 8 multi-ethnic provinces and regions dropped from 39 million to 18 million, a decrease of 21 million. I understood you said 20 million, so I think it's 1 million more than you said, Head of Delegation. That's in your report, but I'm not going to discuss on that. I think that's a lot, and I think it's so good. The incidence of poverty fell from 26% to 12%, a drop of 14 percentage points. The Special Rapporteur on Extreme Poverty and Human Rights on his mission to China on his 2016 report indicates that certain groups are especially vulnerable, such as ethnic minorities, for whom the rate is 12%. So it's the same data that is in your report. International organizations in Beijing estimated that ethnic minorities made up around 1/3 of the total poor population in China, but they're only 8.49% of the population, as you state in your report. I understand then, as you have also said, that the situation has improved a lot in the last years, but ethnic minorities still suffer the greatest rate of poverty and inequality. I understand the very high levels of inequality have been acknowledged by the government in the National Human Rights Action Plan for 2016-2020. And between 1981 and 2007, the Gini coefficient in distribution of net household income in China, I understand, grew from 0.28 to 0.49. But in this, my first question will be, do you have more updated and ethnic disaggregated data on these poverty reduction statistics affecting ethnic minorities? I understand from what I've read that you have a development approach to human rights. Could you think, and I will start the debate here, could you think of changing from a development approach to human rights to a rights-based approach to development? A second achievement related to the one before is that life expectancy at birth rose in China from 67 years to 76.3 from 1990 to 2015. According to paragraph 85 of the State Party report, life expectancy is gradually nearing the national average in ethnic areas. Can you give us more information of the life expectancy in the different ethnic areas and how has it improved in the last 10 years? Another, I understand, positive policy is the adoption and implementation of the National Human Rights Action Plan 2012-2015 and the adoption of the National Human Rights Action Plan for 2016-2020. On paragraph 12 of the State Party report, you state that the June 2016 assessment report on the implementation of the National Human Rights Action Plan of China found that the rights of ethnic minorities had all received protection in accordance with the law. But I think we need more information than that. Did they have indicators of progress on the fight against racial discrimination? What did you achieve in both of the plans? You don't have more data, more indicators, more concrete data of the outcomes of the plan? How did the assessment report help you do new policy measures in addressing discrimination? Was it helpful and how? On paragraph 12 of the State Party report, you state that this third Human Rights Action Plan explicitly proposes to give greater prominence to accelerating the development of ethnic minorities, and you have also stated, I think, in your statement, Head of Delegation, while respecting and guaranteeing the rights of ethnic minorities and lays out provisions for substantive goals, tasks, and measures in that regard. What substantive goals, what indicators of progress have you set in the third plan? Could you update us with the first 2 years of the implementation of this plan with concrete indicators of outcomes that have been achieved? How are you going to evaluate? But who are the left behind? Who are the left behind in the reports and in the indicators you have? And how this left behind affect ethnic minorities? Another positive development on paragraph 25 of the Macau SAR report states that the Macau government has adopted positive measures to publicize and publish the concluding observations of the committee. In fact, it states that the periodic reports and concluding observations of the core human rights treaty bodies have already been uploaded to the webpage of Macau. I would also like to stress some challenges and some comments and questions about the legal, institutional, and public policy framework for combating racial discrimination. First of all, I would like to have more information about the national human rights institutions. Other treaty bodies have asked you about this, like CEDAW, concluding observations in 2014, recommended the establishment of a national human rights institution in China. The Committee on Economic, Social and Cultural Rights, concluding observations, showed a concern about the absence of an NHRI, noting the information provided by the State Party on the establishment of 25 new government institutions with similar functions to those of a national human rights institution. I think treaty bodies, we are expecting a move here from China, and I'm asking if that move is going to happen. In Hong Kong, the Equal Opportunities Commission, the EOC, I understand is not independent from the government, and I understand that few victims are provided legal assistance. We need to know about the efforts in China, Macau, China, to establish national human rights institution. In Macau, I've heard in your statement, head of delegation, you talk about the Committee Against Corruption, but you talk about independence, but then you say that it is appointed by the head of the region. So I don't understand about how this independence works. And you talk about Law 10/2000 in your opening statement. Can you provide us with more details about this law? So I understand that if China and Macau are going to establish NHRI fully compliant with the Paris Principles, and also if the Hong Kong, China is going to render the Equal Opportunities Commission compliant with the Paris Principles. What is the government's view on the way forward on this important issue? Another issue that I think is important is to have more information on the collaboration with NGOs fighting against racial discrimination, more information on China's new foreign NGO management law and about the charity law. I understand that the foreign NGO management law went into effect in 2017. I also understand that you state on paragraph 4 of the State Party report that the report was prepared with the direct participation of persons from ethnic minorities and with relevant non-governmental organizations. Could you tell us how? How many meetings? With which NGOs? How is the collaboration with NGOs in Macau, China, in Hong Kong, China? We have received information that states that both laws have the effect of restricting the funding and on operations of domestic NGOs. I have read that before the law, there were more than 7,000 overseas NGOs were operating in China, but the Overseas NGO Management Law requires, I understand, that foreign NGOs operating in China are subjected to dual management by the Public Security Department and the Professional Supervisory Unit. The information we have received states that 18 months after the law is being implemented, only 385 overseas NGOs successfully registered and established a representative office in China. But of these, more than almost 400, almost 200 are trade organizations and chambers of commerce. And I think the only information we have is that only 5 registered NGOs do work related to ethnic minorities. And none of them, I understand, specifically mention efforts to combat racial discrimination in their registered scope of service. I have read information that states that without meeting the letter of the Overseas NGO Management Law, no organization is able to legally send money into China or receive it from outside China. Is this true? I have read that now a lot of NGOs find themselves in desperate conditions. What information can you give us in this regard? How are you planning to work with NGOs, and what is the government's view on how the collaboration with NGOs could improve? Another issue I think I should raise is the legislation defining racial discrimination and if it's in line or not with the Convention. Despite recommendations by the committee in its concluding observations in 2001 and 2009, I understand that there's still no definition of racial discrimination in China's legislation completely in line with the Convention's provisions. I understand, after reading paragraph 10 of China's State Report, and Article 4 of China's Constitution and Article 9 of the Law on Regional National Autonomy, that ethnic discrimination is prohibited under Chinese law, but the laws you talk about in the report are silent on what type of action or behavior could constitute discrimination. I don't see a definition of discrimination on the basis of distinction, exclusion, restriction, or preference based on race, color, descent, or national or ethnic origin, which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedoms in the political, economic, social, cultural, or any other field of public life as Article 1 of the Convention states. Are you going to enact laws that prohibit discrimination on all grounds referred in Article 1 of the Convention, including a prohibition of discrimination on the grounds of descent and national origin? Do you have any plans on drafting an anti-discrimination law? Do you have any surveys, statistics, administrative records or registers of any kind or reports on how ethnic minorities suffer discrimination in the areas of employment, education, housing, healthcare, or accessing other social services and economic opportunities or in any other field? How does China ensure that laws and policies aimed at counter-terrorism, separatism, or extremism do not undermine the non-discrimination provisions of the Convention and those contained in the Constitution and the law on regional national autonomy protecting members of ethnic minorities? My next issue will be Article 4 of the Convention. I understand that paragraph 51 of the State Party report states that Articles 249, 250, and 251 of the criminal law set out appropriate definitions and sentencing criteria for criminal acts of incitement of ethnic hatred and ethnic discrimination. Can you provide the content of these articles, because I haven't read them, I don't see them in the report. According to the paragraph 31 of the Macau-China report, the criminal code has distinct stipulations to prohibit and sternly repress the crimes related to hatred and discrimination due to nationality, race, ethnic group, or religion. I understand it's Articles 230 to 233 in Macau. Can you provide the content of these articles? The representative of the Macau SAR have also stated that in his opening statement about the aggravating circumstance to homicide. But is this aggravating circumstance new in Macau? Because I haven't seen it in the report. And is it only for homicide? It's not for other crimes? I would like to know about that. Do you have on China, SAR, Hong Kong, China, and Macau, China, statistics and examples of criminal complaints, investigations, prosecutions, sentences, convictions, sanctions and remedies for acts of racial discrimination, including racist hate speech and other racist hate crimes? In the 2009 concluding observations, the committee called upon the State Party to examine why there have been only a few judicial cases in this regard, and it recommended that the State Party verify if the scarcity of such complaints is not the result of lack of effective remedies enabling victims to seek redress, victims' lack of awareness of their rights, fear of reprisals, lack of confidence in the police and judicial authorities, or lack of attention or sensitivity to cases of racial discrimination on the part of the authorities. I understand, reading the 2009 concluding observations and the examples described by the government of China on paragraph 107 of the State Party report, where China describes two examples of criminal court cases on racial discrimination, that I understand that China has again only a few judicial cases of racial discrimination. In Hong Kong, China, it states, I understand, in its annex that racial discrimination is not a prevalent or serious problem. And also, Macau SAR states in its report that the courts did not receive any proceedings related to racism, racial discrimination, xenophobia, and related intolerance. Now, my question will be, why do you think it is so? What is the government position on that? Do you recognize underreporting of hate crimes in China, in Hong Kong, China, and in Macau, China? What have you done to support victims of racial discrimination on reporting their complaints? Civil society organizations have told us cases of hate crimes that were not reported, not prosecuted. One of them was considered a traffic accident without taking into account the prejudice and ethnic hatred involved. Have you verified that the scarcity of such complaints is not the result of lack of effective remedies enabling victims to seek redress, victims' lack of awareness of their rights, fear of reprisals, lack of confidence in the police and judicial authorities, and lack of attention or sensitivity to cases of racial discrimination on the part of the authorities, as the committee recommended in 2009? In Hong Kong, the Equality Opportunities Commission report states that there has been a growing reporting on online hate messages and racial vilification. I understand that more during the elections, particularly targeted at South Asians as well as asylum seekers and some at NGOs working with these groups. While they say that while the average number of racial vilification complaints received from 2009 to 2015 was 3.7, the number was 47 for the year 2017 alone. What do you think are the reasons for that? How is the Hong Kong SAR government responding to this? What are your plans? What is the situation of hate speech in mainland China and in Macau, China? Now I will pass to the situation of racial and ethnic minorities in China, Hong Kong, China, and Macau, China. The State Party report responds to the third 2009 concluding observations, and they respond in paragraphs 17 to 47. The UN Special Rapporteur on Extreme Poverty and Human Rights stated that the situation of Tibetans and Uyghurs are deeply problematic. He stated that most ethnic minorities in China are exposed to serious human rights challenges, including significantly higher poverty rates, ethnic discrimination, and forced relocation. The Committee on Economic, Social and Cultural Rights, concluding observations, expressed also concern about the persistent and widespread discrimination against ethnic minorities, particularly in the Western provinces and regions, especially in the fields of employment, social security, housing, health and education, in spite of efforts taken by the State Party. Ms. Gay McDougall and Ms. Bryn Shepherd, among others, are going to talk more about these issues, so I will just raise 3 other issues in this regard. I understand from the information we have received that despite Hong Kong, China, having one of the highest rates of GDP per capita in the world, inequality has worsened. The Hong Kong Poverty Situation Report on Ethnic Minorities 2016 tells us that the rate of ethnic minorities living below the poverty line has risen from 15.8% in 2011 to 19% in 2016. And also the poverty rate of South Asians was at 25.7%, with Pakistanis registering a high poverty rate of more than 50%, of 56.5%. How are the authorities of the Hong Kong SAR going to deal with the increase of poverty rates for ethnic minorities? The next issue I will raise is the unemployment and the employment situation of ethnic minorities. The Committee on Economic, Social and Cultural Rights regretted, the COPS, the concluding observations, regretted that the statistical data on unemployment rate were not currently disaggregated by ethnic origin. The Committee on Economic, Social and Cultural Rights remained concerned about reports of high rate of unemployment among persons belonging to ethnic minorities, especially Tibetans, Uyghurs and Inner Mongolians, in part due to Han Chinese migration into minority areas. Paragraphs 78 to 81 of the State Party report, in response to the Committee's 2009 concluding observations recommendation, say that provisions prohibiting employment discrimination against ethnic minority workers are included in many laws and regulations, such as the Regional National Autonomy Law, the Labour Law, the Employment Promotion Law, and the provisions of the State Council on the implementation of the Law on Regional National Autonomy. I understand, as you say in the State report, these laws prohibit discrimination. But what happens when discrimination occurs? I don't see data on that. Do you have data on what happened when discrimination occurs? Do you have data on the number of sanctions on employment, racial discrimination on China, Hong Kong, China, Macau, China? Which one is the body in charge on inspecting and vigilating this? I don't see it in the report. We have received information that says that rapidly developing industries, including the energy service sector, construction, resource extraction, and government positions are dominated by Han Chinese living in the Xianggang Uyghur region, and Uyghurs are excluded from the good employment opportunities. And that some companies, like the company Foxconn, explicitly stated in 2016 they would not hire ethnic Tibetans, Uyghurs, and Yi people. However, I have read that the government did not file a single case against such companies or agencies. Ethnic minorities, I've read, have difficulties reporting labor discrimination. Additionally, I've read that hiring practices are discriminatory within some companies in Tibet, which preference Han Chinese migrant labor over Tibetans, who are often restricted to jobs requiring requiring the lowest skill levels. This, I understand, will also mean that wages are not invested back into the local economy, and when Han Chinese workers leave, they also take the acquired skills. I have also read information that states that the huge investment and economic development in Tibet appear to be mainly geared towards the Han Chinese population because the Chinese government has encouraged Han Chinese to settle in Tibet, where they then enjoy preferential access to employment and education. I understand that China has not ratified ILO Convention number 81 on the Labor Inspection Convention. Is this so? That I understand that Macau, China, and Hong Kong, China have ratified. Is that correct? I understand in Hong Kong, is the Equality Opportunities Commission the one who deals with these issues? What budget and personnel, labor inspectors, if they exist, the Equality Opportunity Commission, or whatever body deals with these issues, do they have to analyze, inspect the situation and apply administrative procedures and sanctions against racial discrimination on employment issues? Is all the burden of reporting on the victim? Do labor inspectorates or other body investigate these issues? Do they act de officio without the victim needs to report? We all know racial discrimination in the employment is very difficult to prove, and without an inspectorate well-trained, it's going to be very difficult for a victim to report. Are you planning on acting in that direction? How do you help victims of employment racial discrimination to report? The state report also says that since 2008, the Chinese government has taken numerous measures to promote the employment of members of ethnic minorities. The State Party report says that special recruitment activities aimed at college graduates from Tibet, Xinjiang, and Xinjiang are being organized. What have been the outcome of your policies? What protections are embedded within the One Belt, One Road initiative that will ensure that ethnic minorities are included and benefit from the project? Do you have statistical data on employment, unemployment, and activity rate disaggregated by ethnic origin? We have also received information that states that ethnic minorities often face direct and indirect discrimination when seeking accommodations. What discrimination do ethnic minorities face when they try to access public or private housing in China, Macau, China, and Hong Kong, China? What policies and measures are taken to avoid it? Another issue, the CERD in 2009 said it was concerned at reports alleging the disproportionate use of force against ethnic Tibetans and Uyghurs and the important number of detentions. I don't have all the time needed to deepen on these issues, and I will not raise them because my colleagues are going to talk about them, but the information we have received is worrying. But I do want to raise the issue that the Committee Against Torture also stated in its 2016 COPS, concluding observations, about numerous reports from credible sources that document in detail cases of torture, deaths in custody, arbitrary detention, and disappearance of Tibetans, and about acts directed against Uyghurs and Mongolians. In view of this information, the committee remained seriously concerned at the State Party's failure to provide information on 24 out of the 26 Tibetan cases mentioned in the list of issues, despite the questions posed by the committee during the dialogue. The committee urged the State Party to provide the requested information and urged the State Party to ensure that all custodial deaths, disappearances, allegations of torture, and ill treatment and reported use of excessive force against persons in the autonomous region of Tibet and neighboring Tibetan prefectures and counties, and in the Xinjiang Uyghur Autonomous Region were promptly, impartially, and effectively investigated by an independent mechanism. We have received information about cases in which Tibetans, Uyghurs, and other ethnic minorities alleged to have been tortured or otherwise ill-treated. Will you impartially and credibly investigate officials implicated in the ill-treatment of Tibetans, Uyghurs, and other ethnic minorities and appropriately bring them to justice? How has your government taken steps to prevent torture relating to cases related to national security that affect ethnic minorities? The next issue, I will make some comments and questions, is the situation of non-nationals. I understand China is both a country of origin and a country of destination, mainly of South Asians, but there are no statistics on the report and no data except for the Macau SAR China. I have read in the 2017 International Migration Report of the United Nations that in China, in the year 2000, there were 508,000 international migrants. And in 2017, there are about 1 million international migrants. I've also read in that report that in Hong Kong, China, there were 2.6 million in the year 2000 and 2.8 million in the year 2017. And in that report states that Macau, China, there were 241,000 international migrants in the year 2000 and 354,000 in the year 2017. There's data on paragraph 6 of the Macau, China report that gives data of non-resident workers. It says that in 2014, there were altogether 170,000 non-resident workers, and gives data on the countries of origin. So my question will be, do you have statistics available on non-nationals disaggregated by national origin in China and Hong Kong, China? Are the ones on that UN report that I have mentioned correct in your view? Are they official data? What kind of policies are you promoting on the integration of international migrants? Another issue is about trafficking. Do you have updated information on anti-trafficking legislation and statistics on complaints, investigations, prosecutions, convictions, sanctions and remedies for human trafficking, statistics indicating the ethnicity and nationality of trafficking victims in China, Hong Kong, China, and Macau, China? I've read about the National Plan of Action on Combating Human Trafficking 2013-2020, but I haven't seen any information on the report. Could we have some information on that national plan? I understand that China and Hong Kong, China do not provide information on trafficking in their report. Macau, China's report does it on paragraphs 61 to 72. I understand that the Hong Kong SAR government's adoption of the action plan to tackle trafficking in persons and to enhance protection of foreign domestic workers in Hong Kong 2018 is a welcome initiative. However, we have received information that civil society was not consulted in its development, and they were informed only after it was approved. Is the protocol to prevent, suppress, and punish trafficking in persons, the Palermo Protocol, applicable in China, Macau, China, and Hong Kong, China? Are China and Hong Kong, China going to enact a comprehensive anti-trafficking law that criminalizes all forms of trafficking? Are China and Hong Kong, China, and Macau, China going to strengthen support and protections for victims of trafficking? We have also received information that states that despite being born in Hong Kong, having grandparents that were migrants, some ethnic minorities face immense difficulties when applying to be naturalized as Chinese nationals. Do you have statistics on access to nationality on China, Hong Kong, China, and Macau, China? What are the requirements for naturalization? Are they public and known? How are applicants notified of the reasons for refusal? Are China, Hong Kong, China, and Macau, China going to ratify the International Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families, and ILO Conventions number 29, 81, 105, and 189? They are in Forced Labor Convention, Labor Inspection Convention, Abolition of Forced Labor Convention, and Domestic Workers Convention. I would also like to raise one more issue, and I will finish my time, Chair, specific to Hong Kong, China, and the efforts to amend the Race Discrimination Ordinance, the RDO. On the 2009 concluding observations, the committee expressed its concern about the definition of racial discrimination given in the RDO, which was not completely consistent with the Convention. In paragraph 1.4 of the Hong Kong report, it states that Hong Kong is carrying out a review of race and the RDO, and you also said in your opening statement, the representative of Hong Kong, China. But I understand that the Equality of Opportunities Commission completed the discrimination law review and submitted the recommendations to the government. But in March 2017, the Constitutional and Mainland Affairs Bureau responded and prioritized. I thought it was at 9, I understood you said 8, and then 7 of which concerned the RDO. I think you said 6, I don't know. However, I understand that these recommendations, none of them concern discriminatory acts of the government in the performance of its functions and in the exercise of its powers. I understand in October 2017, the Hong Kong SAR government announced that it would propose legislative amendments, but none of these amendments, I understand, and it's the information I have, give effect to the changes recommended in the 2009 concluding observations of CERD. So my question would be, is the government going to amend the RDO to include nationality and immigration status as a protected characteristic? And is the government going to amend the RDO so it covers government powers and functions? Well, Chair and representatives of the State Party, there is a lot more to say, a lot of issues that I haven't raised, but I'm sure the co-rapporteurs that now, Ms. Gay McDougall and Ms. Rachel Shepherd and the other members of the committee will raise them, and we can have a fruitful and constructive dialogue where we can all learn more about the Chinese reality and about the fight you are having in your country against racial discrimination and the way we can help you improve in that fight. Thank you so much.
Merci, Monsieur le...
Thank you to the rapporteur. And I will now give the floor to Ms. McDougall. You have several minutes for your statement.
I want to also warmly welcome the delegation, the large and impressive delegation from the State Party. I have been asked by the rapporteur to cover issues relating to the Uyghur minority group in general and the autonomous region for Uyghurs. I would say that we are deeply concerned at the many numerous and credible reports that we have received that in the name of combating religious extremism and maintaining social stability, the State Party has turned the Uyghur autonomous region into something that resembles a massive internment camp that is shrouded in secrecy, a sort of a no-rights zone, and that members of the Uyghur minority, along with others who are identified as Muslims, are being treated as enemies of the state based solely on their ethno-religious identity. There are reports of mass detentions of ethnic Uyghurs and other Turkic Muslim minorities. There are estimates that upwards of 1 million people are being held in so-called counter-extremism centers, and another 2 million have been forced into so-called re-education camps for political and cultural indoctrination. Others are under a form of house arrest. These detainees are almost all from the Uyghur minority group or other targeted minorities. Others may have traveled outside the country or have relatives who have done so. All of these detainees have had their due process rights violated. Most have never been charged with an offense, tried in a court of law, or afforded an opportunity to challenge the illegality of their detention. Many just disappear. Their relatives never know what happened to them. Reports indicate that the State Party is making even the most commonplace expressions of ethno-religious significance to Muslims into penal offenses, such as daily greetings, possession of certain halal products, wearing a long beard or a full face headscarf, and refusal to watch state television. All of these have at times apparently been grounds for detention. There are reports of mass surveillance disproportionately targeting ethnic Uyghurs, including those frequent stops by police and mobile scanning of phones at checkpoints. It is reported that in the Uyghur Autonomous Region, the State Party also imposes mandatory collection of extensive biometric data, including DNA samples and iris scans, of all residents between the ages of 12 and 65. Reports also indicate that all residents of the region are required to hand in their travel documents and then apply for permission to leave the country, and that permission may not come for years. And this has particular impact on those who wish to travel for religious purposes. Recent amendments to the legal framework appear designed to enable even greater control over the Uyghur minority and other minority groups. I refer to the criminal law amendments, the national security law, the counterterrorism law, the cyber security law, and the religious affairs regulations law. These new amendments to the legal framework, among other problems, establish imprecise and overbroad definitions of national security offenses, including offenses related to terrorism and extremism that enable abusive, arbitrary, and discriminatory prosecutions and conviction. There are reports that in April 2017, the government in the
Madame McDougall.
Ms. McDougall, you have exhausted your speaking time. Given the speaking time given to Mr. Marugan, which was 35 minutes, and it's now 44 minutes since we started hearing from the co-rapporteurs, I'd like to give the floor now to Ms. Vereen Shepherd. Thank you very much.
Thank you, Chair. Can you clarify, Chair, how many minutes I have as co-rapporteur? Ten minutes.
8 à 10 minutes.
8 to 10 minutes. 8 to 10.
Thank you, Chair. I want to welcome the distinguished delegation from China, as well as all the NGOs gathered here, and I'll proceed to pose some questions relating to education, as requested by Senor Marugan, the country rapporteur. Now, these questions stem from issues raised in the list of themes, the last concluding observations, the State Party's core document, and the periodic report, as well as from information submitted by NGOs. We are aware, as stated in paragraph 73 of the SPR, that the Chinese government vigorously supports the implementation of compulsory education for ethnic minorities. You have indicated that the Chinese government pays great attention to the promotion of and education about ethnic unity and progress. The Central Committee's Publicity Department, the Ministry of Education, and the State Ethnic Affairs Commission have issued promotional material on educational activities on ethnic unity in schools and the human rights-related content of the Universal Declaration of Human Rights, the United Nations Declaration on the Elimination of All Forms of Racial Discrimination, and the ICERD is commonly included in the content of courses taught at institutions of higher learning and in the training of judicial, law enforcement, and administrative personnel. The State Party has also mentioned its work and policies being implemented towards bilingual education. But articulated policies are not always implemented. Therefore, there are lingering concerns about the ways in which the Uyghurs and communities in Hong Kong and Tibet and Macau are impacted by the failure to carry out written policies. So, if I may, I'll summarize our main concerns regarding education policy. Now, these concerns are mainly related to the results of legislation and policies aimed at improving the quality of education, providing bilingual education in ethnic minority areas, improving conditions in state-run boarding schools in those areas, improving literacy rates in ethnic minority areas, and ensuring access to education for ethnic minority children. We also need disaggregated data by ethnic groups showing access to primary and secondary education as well as updated enrollment figures. I'm also interested to inquire about dropout rates by ethnic groups and an idea of the causes of dropout, because we know that enrollment, because of some challenges, are sometimes below what they should be. In the areas of culture and education, the Chinese government says that it is increasing its affirmative bias toward and support of minority nationalities. The Constitution, the law on regional and national autonomy, and the compulsory education law of the People's Republic of China all contain provisions clearly mandating support for and assistance to education development for minority nationalities. In fact, we note that various laws, including the Constitution, contain provisions in relation to the use of ethnic minority languages. We recognize the good intentions of these laws, but we are not sure from the report how much has been done beyond the promulgation of these laws. And so could you inform us on how these laws are working in practice? There is a Chinese as second language policy, which the head of delegation mentioned, which is to be applauded, given that so many people, especially in Hong Kong, under the English for some time, as we all know, do not speak Chinese. But claims are loud, head of delegation, that the Chinese government does not attach as great an importance as it claims to bilingual education work with ethnic minority students, that the program is under-resourced and that there are insufficient trained teachers to implement the policy, for example, in Hong Kong. In the last concluding observations, the committee had expressed concern at reports that in practice, Mandarin is the sole language of instruction in many schools in the autonomous minority provinces, especially at secondary and higher levels of education. So we still do need an update on the progress regarding the Chinese language curriculum, second language learning framework in Hong Kong, China, as there does not appear to be policy goals, outcome indicators, detailed implementation plan or timetable, and a monitoring and evaluation mechanism. Limited guidance has been provided to schools on pedagogic principles, and the teachers are not required to be trained professionally before teaching Chinese as a second language. So the framework also lacks accountability to parents. Segregation rather than integration appears also to be the situation in the schools in Hong Kong. Despite the disbanding of English medium designated schools, the majority of ethnic minority children continue to attend a few former designated schools, resulting in de facto ethnic segregation that impedes Chinese language learning, social integration, and career projects. According to reports received, segregation often begins in kindergarten, where admission interviews are often given in Cantonese and admission forms may not be available in English for parents. In Hong Kong, 60% of children from ethnic minorities are concentrated in a few former designated schools, which are public schools with ethnic minority comprising 80 or 90% of the student body. These schools are neither conducive to students' Chinese language learning nor their social integration. Therefore, ethnic minority students graduating from these schools often have limited Chinese language ability, dramatically affecting their social integration and career prospects. Mr. Chair, I want to stop here because I know other members of our committee would like to ask other questions. But I would like to ask you for more time, if I'm able, to bring up other issues concerning the bilingual policy in Tibet and among the Uyghurs and the impact that this is having on the policy of respecting minority languages. Thank you, Chair.
Merci, Madame.
Thank you. Without further ado, I'd like to give the floor to Mr. Kut, who is in charge of follow-up for hearing a status report. Mr. Kut, you have the floor, sir.
Thank you, Chair. I would like to join my colleagues before me to extend a warm welcome to the delegation from China, as well as from the special administrative regions of Hong Kong and Macau. I would also thank them for their contribution to this discussion and hope for a positive and fruitful discussion today and tomorrow. I would also say that I consider our committee lucky to have as a member a national of the state party in the person of Madam Lee, whose contributions to our work was aptly summarized by our rapporteur, Mr. Marugan. I would also commend Mr. Marugan's and Madam McDougall and Madam Shepherd's extensive coverage of the situation in the state party as rapporteur and co-rapporteurs. In my function as the follow-up rapporteur, I will simply focus specifically on the 4 issues that were raised in the previous concluding observations in 2009, which were actually expecting an interim report within 1 year of the concluding observations, and the state party effectively and successfully provided us with this, and I commend the state party for that punctuality. I want to underline that the committee attaches a great importance to this process of follow-up, and it is a positive aspect in our discussion that the state party has provided this interim report on time. The committee, the satisfaction of the committee varied in its evaluation of the interim report, but I'm not going to deal with that. Instead, since most of these issues still persist, as our rapporteurs also underlined, I will simply touch upon them and raise a few questions. First, the first issue was on the extension of the National Human Rights Action Plan beyond 2010. This we understand from the paragraph 12 of the State Party report that was duly conformed with, and there was an extension of the National Human Rights Action Plan a second time, and also a third time, this third plan covering the period 2016 and to 2020. This is a good development. We appreciate this. But as the country rapporteur also suggested, we would like to see more examples of concrete results of the implementation of these plans. Plans are good, but implementations are important because plans are not ends in themselves. So we would like to see you telling us about the results. The second issue that was raised in 2009 was that the state party was asked to take effective measures to ensure that the application of administrative detention and re-education through labor is used restrictively and be subject to full judicial control. Now, at the end of this suggestion, the committee recommended that these practices should actually end. Now, we find out from the paragraph 14 of the State Party periodic report that the system is in fact abolished in 2013 in response to the recommendation of the committee, which also is a commendable effort. We appreciate this very much. So we see that at least at the legislative level, we do not have anything like administrative detention and re-education through labor type of legal frameworks. However, there are reports that in practice these have become policies, and actually they continue in different shapes and forms, which is alarming for the committee, because now the situation, at least theoretically, seems to be worse, because if in practice this exists, it doesn't even have a legal basis. So we thought we were facing a better situation, but maybe we are not. So we would like to have more clarification on that and more light to be shed on this important issue. The third point, Mr. Chair, dear colleagues, was that the state party was asked to take all appropriate measures to ensure that the lawyers can exercise their professions freely, investigate all allegations of harassment and intimidation of lawyers taking up cases of human rights violations, revise all laws that are inconsistent with the lawyers' law and international standards. The State Party report addresses these issues in paragraphs 105 and 106. We find out that there was amendments to the lawyers' law. However, there are also reports that there were other developments at the administrative side of the lawyers' professional activities, and that the harassment and intimidation of lawyers dealing with human rights issues again continue in other forms or shapes, such as disbarment or administrative punishments of various sorts. So, is that the case? Please give us more information, and please convince us that it is not the case. Finally, Mr. Chair, dear colleagues, the last issue that was reminded the State Party to brief within 1 year was migrant workers, especially domestic workers in the Special Administrative Region of Hong Kong. The committee asked the Special Administrative Region to repeal the 2 weeks rule as well as the live-in requirement for the domestic workers, and in general to adopt a more flexible approach to domestic migrant workers. Now, we have the representative of the Hong Kong Special Administrative Region, member of the delegation, in his contribution basically told us that this is not going to take place. And the report, this issue is addressed in a separate report for Hong Kong, CERD CHN-HKG 14 to 17, in paragraphs 2.21 to 2.34, at length, I would say, but I do not think to the satisfaction of the committee. So if there is more to be said about this particular issue, we would like to hear it from the relevant authorities in the delegation. With that, Mr. Chair, I conclude my remarks. Thank you very much.
Monsieur Kut.
Mr. Kut, thank you very much. I would now like to give the floor to Mr. Khalitsai. And perhaps I could simply say that we have how many? 8 requests for the floor. So, Mr. Khalitsai, you have the floor first. You have the floor. You'll be followed by Ms. Ishak Ndiaye. You have the floor. Thank you very much, Mr. Chairperson. I would like to welcome the distinguished delegation from China, continental China, Macau, and Hong Kong. I think it is important to have you present here to resume this dialogue, which is so important with respect to our convention and truly to comply with what is set out in the convention. I'm not going to be able to address all of the issues relating to China. My colleagues have already focused on some of the more in-depth areas. I would like to rather just talk about Article 5 of the Convention, which in accordance with the fundamental obligations stipulated in Article 2 of this convention, state parties shall be committed to eliminating racial discrimination in all of its forms and to guarantee the right of all people to equality before the law without distinction as to race, color, or ethnic background, particularly when it comes to the enjoyment of the following rights: the right to move freely and to select their residence within the territory of the state, the right to leave any state, including their own, and to return to that state, the right to a nationality, the right to freedom of thought, of conscience, and of religion, the right to freedom of opinion and freedom of expression, the right to freedom of assembly and peaceful association, and the access to all public places and media, sports, cafes, recreational areas, and parks. Of course, inter alia, including other civil and political rights. In this context, we have received information to the effect that the State Party has not complied fully with Article 5 of these obligations, and it restricts, in particular, right to free mobility for some of the population, particularly the population in the Tibet Autonomous Region, where often the people are prevented and prohibited from leaving their region and even from their own area, whereas the Han are allowed to move freely throughout the country. Of course, the committee understands that there is extreme poverty in rural areas. In paragraph 48 of your report, the State Party has recognized this. In what way are you trying to combat extreme poverty in rural areas? And basically, I would like to talk about the law against terrorism and illegal religious practices. What is the ideological basis that is being used for the accusation of terrorism against Tibetans? We would appreciate having more information with respect to these religious practices which are distorted or illegal, which the Tibetans are practicing, so that they are being converted into terrorist extremists and constitute a threat to the security of the state. With respect to Tibetan Buddhism, are using this law to attack traditional Tibetan religious practices, which the international community at least considers not to be dangerous with respect to the national security of the state. China is known internationally for its huge millennia-long cultural heritage. I come from Guatemala, where we also have a culture going back millennia, which is recognized internationally. Our states are doing their utmost to recognize this millennia-long cultural heritage, and in the Constitution, there is an attempt to reflect this multiculturalism and this cultural heritage which these people who have lived for millennia have. China is a country which has a great tradition as well. Do you not think that recognition of these millennia-long heritage would only enhance your cultural heritage? Assimilation culturally has never been a good thing, and cultural assimilation, in fact, gives rise to extremism. Often, recognition and freedom of cultural and religious practices are factors that allow these great states to be even greater. Against this backdrop, I am very worried because I have received information to the effect that religious festivals, I am just concluding, Mr. Chairperson, that Tibetan religious festivals have security measures imposed on them concerning the people coming to these festivities. And I will finish by saying, Mr. Chairperson, that there are national parks which are being set up to maintain and preserve the environment in China, but these parks are basically part of the territories where the religious practices of these peoples are centered. And is it not sometimes being done with a view to eradicating these religious practices and traditions? I have a few other questions, but perhaps on Monday I'll have another chance to ask questions. Thank you very much.
Muchas gracias, señor.
Thank you very much, Mr. Kalitsai. For sticking to the time limit. Thank you very much, Mr. Kalitsai. Ms. Ndiaye?
Please.
Thank you, Mr. Chair. Let me also welcome the delegation of the People's Republic of China. And if I may also thank explicitly for the handouts, which are always very useful, as we are trying to process a lot of information, and it makes it easy for us to look up the data we need. In my intervention today, I would focus on three issues. The first will be refugees and asylum seekers. The second will be non-refoulement. And the third one will be statelessness. And I try to keep to the time limits and be as brief as possible. So on the very first subject on the situation of refugees and asylum seekers, in our last concluding observations in 2009, we noted the process of drafting a refugee law in mainland China, while we expressed our concern that asylum seekers from the Democratic People's Republic of Korea continue to be systematically refused asylum and forcibly returned. In relation to Hong Kong SR, the committee noted the planned legislative framework for torture claimants and remained concerned that the state party has not adopted a refugee law as such, including a screening procedure for asylum claims. Now, I understand that in Macau SR, the convention relating to the status of refugees and the protocol are both applicable. And in order to implement the convention and the protocol, a law 1/2004 was adopted, the regime of recognition and loss of refugee status, and also a refugees commission was established to be responsible for analyzing applications for the recognition of refugee status. And I would also like to thank the representative for the updated information we received today at the beginning of the session. However, I also understand that in mainland China, efforts to develop a comprehensive refugee law was reportedly initiated in the 1990s. And although at the end of 2008, a refugee regulation was drafted with input from all relevant ministries and submitted to the State Council for final deliberations, the law has never been adopted. In 2012, the Standing Committee of China's National People's Congress adopted a new administration law on entry and exit, which means that currently China has incorporated only a few provisions of the Refugee Convention and Protocol into its domestic law, and has not established a national mechanism for refugee status determination. Domestic Chinese law contains no provisions on who qualifies as a refugee, which organization or government body is responsible for refugee status determination, or how an application for refugee status can be made. And as regards Hong Kong SR, the committee understands that Hong Kong has the position that due to its unique circumstances, the Refugee Convention and the Protocol is not applicable to the region, and that it does not plan to depart from this position. So in this regard, we would welcome further information on the legislative protection and procedures for refugees and asylum seekers, on the availability of appropriate information, interpretation, on legal and humanitarian assistance and judicial remedies to asylum seekers in China, Hong Kong, China, and Macau, China. Now, the second issue would be non-refoulement. And in 2009, as I mentioned, the committee has already expressed its concerns about the forced returns of asylum seekers of the Democratic People's Republic of Korea. In the meantime, the 2014 report of the Commission of Inquiry on Human Rights in DPRK stated that despite the gross human rights violations awaiting repatriated persons, China pursues a rigorous policy of forcibly repatriating citizens of the Democratic People's Republic of Korea who cross the border illegally. China does so in pursuance of its view that these persons are economic and illegal migrants. However, many such nationals of the Democratic People's Republic of Korea should be recognized as refugees, fleeing persecution or refugee surplus. They are thereby entitled to international protection. The Commission found that in forcibly returning nationals of the DPRK, China violates its obligation to respect the principle of non-refoulement under international refugee and human rights law. So moreover, the Commission stated that discrimination against women and their vulnerable status in DPRK, as well as the prospect of refoulement, make women extremely vulnerable to trafficking in persons. And many women are trafficked by force or deception from the DPRK into or within China for the purposes of exploitation in forced marriage or prostitution under coercive circumstances. An estimated 20,000 children born to women from DPRK are currently in China, who are deprived of their rights to birth registration, nationality, education and healthcare because their birth cannot be registered without exposing the mother to the risk of refoulement by China. As regards Hong Kong SR, I also would like to thank for the update today, especially on the various support services. But I understand that the unified screening mechanism that started in 2014 now has to deal with a total number of claims with more than 10,000. The Committee on Torture stated in its 2016 concluding observations that it is concerned that only 32 non-refoulement claims out of 6,628 were considered substantiated, which is indicative of a distinctly high threshold for granting protection. And it also remained concerned at the plans to fast-track the system to address this backlog. I also understand that the government communicated that it will conduct a comprehensive review of the strategy of handling non-refoulement claims, including a review of the immigration ordinance, and will expedite screening of claims to address various problems, such as illegal immigration and overstaying. So in this regard, we would welcome further information and updated statistics on non-refoulement claims filed, granted, and pending processing in China, Hong Kong, China, and Macau, China. And now my very last point is on statelessness and stateless persons. And we have little information, especially when it comes to disaggregated data. But as I mentioned, it is estimated that 20,000 to 30,000 children to North Korean parents in China have no nationality and therefore cannot access education, healthcare, citizenship, and basic rights. If the mothers are deported, they are often abandoned by the Chinese fathers, leaving them effectively orphaned. Furthermore, marriage relationships of North Korean women to Chinese men are often not legally recognized. Registering the child simply to attend school in China places the mother at high risk of deportation. And according to information received about Hong Kong SR, children who are born of non-refoulement claimants are deprived of their right to become citizens of Hong Kong, and their birth certificate states not established as their status. So in this regard, we would welcome further information and statistics disaggregated by ethnicity on stateless persons, on the availability of residency cards for children of refugees, and on measures taken to address the situation of stateless children and of asylum seekers. Thank you.
Merci, Mayor.
Thank you very much. So we are going round the table now, and given the number of requests for the floor, I'm not sure if we'll be able to give more time to the speakers, but we will all cooperate. And I will give the floor to Mr. Abulbeck.
Thank you, Mr. Chairman. I would appreciate if the distinguished delegation of the People's Republic of China could comment on 3 issues I intend to raise. The first one has to do with unrecognized ethnic groups According to data provided by the State Party, in 2010, there were over 640,000 people who did not belong to one of the 56 recognized ethnic groups in China. Reports indicate that they may have difficulty obtaining political representation and special measures as minorities. The second issue has to do with the Inner Mongolia Autonomous Region. There are reports of state surveillance and harassment of individuals peacefully protesting coal mining, deforestation, and other development activities on traditional pastoral lands that have resulted in environmental harm and mass resettlement of ethnic Mongolians. Their resettlement to predominantly Han areas and the accompanying restrictions on their mobility threaten their traditional livelihoods as herders and have reduced the availability of Mongolian language public schooling. And the last issue has to do with the resettlement and land exploration. Reports indicate that a large number of farmers, including from ethnic autonomous areas, have lost their land and farm-based livelihoods due to poverty alleviation efforts to resettle farmers to urban areas, and that compensation for expropriated property, while provided for by law, is often insufficient to maintain an adequate standard of living. Thank you, Mr. Chairman.
Thank you for being so precise and concise. Thank you for your understanding. Mr. Murillo, you have the floor. Thank you, Chairman. I also share with all the thanks to the rapporteurs and Ms. Lee herself and everyone else. Chairman, the report by the State Party in paragraph 49 refers to China's position on racism and racial discrimination, and it highlights its role in the Vienna Conference, the Durban Conference, and the Review Conference in Durban. And in paragraph 37 of the document itself, the State Party highlights its role in international cooperation to combat racism and racial discrimination. The world is increasingly smaller. We all acknowledge that. There is growing interdependence, and we are increasingly concerned by racism at global level. And in recent times, we have seen that people of African descent are the victims of racism and racial discrimination, and China is no exception. In Hong Kong, there have been incidents that have had an impact on people of African descent. But in the broader context, let us recall how China in the past was the victim of discriminatory legislation from other countries, legislation which banned Chinese citizens from entering a country. This is the International Decade for People of African Descent, and in the first year, 2015, Latin American, Caribbean countries urged the international community to organize the 4th International Conference to combat racism and racial discrimination and xenophobia. So, whilst awaiting the responses of the State Party, Chairman, I would like to recall this renewed commitment from China in these fields, which is included in its report in paragraphs 37 and 49 and in its original document. And I would like to ask China to consider joining support for the convening of this 4th International Conference to combat racism and increase support for the International Decade of People of African Descent. So that's one thing. Then, Mr. Chairman, the report by China in paragraph 34 refers to its role and its commitment to ecological development and highlights the role of ethnic groups. We are currently facing huge challenges with regards to climate change, and taking into account China's huge impact on global warming, I would like to know about the role of ethnic groups in China's environmental policy. And in that context, what initiatives are being taken by China to strengthen this participation? That is all for now. Thank you, Chairman.
Merci, Monsieur.
Thank you, Mr. Murillo. Thank you for your understanding. And now I would like to give the floor to Madame Da. You have the floor, Madam.
Madame Da, vous avez la parole.
Madame Da, you have the floor.
Monsieur Diaby, vous avez la parole.
So, Mr. Diaby, you have the floor. Thank you, Chairman. I, too, would like to congratulate the Chinese delegation from mainland China and Hong Kong and Macau for their very detailed report and presentations. I would also like to congratulate the rapporteur and the co-rapporteurs for the work they have done and the questions raised. I would like to have some information on agriculture, health, media, and education. In paragraph 98 of the report, the State Party says it respects the customs of minorities. What about, how does that work with the media? Do these minorities recognize themselves as portrayed in the public media? Then, with regards to education, The state party refers to promoting equality and equal opportunities. What does this mean in terms of handbooks or manuals to take on board the concerns of different minorities? And in Hong Kong, I believe that with bilingualism, Mandarin is taking over from Cantonese in exams to have access to higher education. With regards to agriculture, China said that in 2020 it will eliminate the differences between the registration of agricultural, non-agricultural workers. Could you give us more information about that? I know a lot of effort has been made with regards to health and the budget allocated to health and healthcare, and yet I believe there are still difficulties in having access to prenatal care and hospitalization for minorities. So I would like to request more information about that. We're pleased to see that the state party has banned forced organ transplants as of the 1st of January 2015. I'd like some information on that. Those would be all my questions, and I would like to thank the delegation for all the information they have provided to the committee. Thank you. I would like to thank you, Mr. Diaby. Mr. Avtamnov, you have the floor.
Merci, Monsieur le Président.
Thank you, Chairman.
Just to greet warmly the delegation of China. As Mr. Marugan told us, we're meeting regularly, but we would like just to see you more and more and oftener, because we like to have discussions with you. We have a lot of things just to point out and just to say. I'm very pleased to Mr. Marugan for his presentation and his co-rapporteurs, Madam McDougall and Madam Shepherd. And I'll touch upon only one point. It's just migrant domestic workers in Hong Kong and Macau. I'm a little bit hesitating how I'm supposed to call it, Macau or our main. I don't know, because we use it to call it Macau, but it has also another official name as well as Hong Kong. It's called Xianggang, as far as I understand it. But I'll call it in a traditional way. Okay. So the situation is not is different in both districts. In Hong Kong, they're just domestic workers invited earlier, and it's just the quantity of foreign domestic workers is increasing all the time. For example, in 2007, there were a little bit more than 246 persons working as domestic workers, while actually it's nearly 380,000 migrant domestic workers, just around, and they're taking care of around 11% of household families. It's important just to point out, it's important to point out that the legislation in Hong Kong, in Xianggang, is just give equal rights to to foreign domestic workers and to local workers. It's just general legislation which has quite a lot of different provisions, which is guaranteeing which are guaranteeing rights of domestic workers, but there is no, unfortunately, monitoring and complaint mechanism. We know that domestic workers who are working just in specific household, they do not have just possibilities to appeal. Sometimes they're afraid of appealing. They are separated, although they just have the right just to create trade unions. And I know that 6 organizations of migrant domestic workers from various countries have created a Federation of Asian Domestic Workers Union, which in 2011 affiliated with the Hong Kong Trade Union Confederation. But we know, on the other hand, that the state needs more efforts just to monitor independently of the domestic workers, to monitor their conditions of their work. That is why, in many cases, they are subject to abuse by their employers, who just try to create worse conditions that just prescribed by the law. And among well-known cases is a case of Erviana, an Indonesian migrant domestic worker who was severely maltreated by her employer. At least it is just stated in mass media. And this is not just an isolated case. So from that point of view, I'll be very grateful to the delegation if they have any ideas in this field, if there is any initiatives of the government to create such monitoring mechanisms. And then there is there is a certain problems with trafficking in domestic workers, because some of them cannot go through the official gates, and they're also subject to abuse. And unfortunately, in Shanghai, Hong Kong, there is no legal provision that deals specifically with human trafficking. There is a section 129 of the Crimes Ordinance, which applies only to trafficking across borders for the purpose of prostitution or commercial sex exploitation. But probably there is a necessity of a broader mechanism and broader legislation. I'm very pleased that in your opening presentation you just mentioned this action plan with a long name, which was adopted this year. I don't mean just to dealing with human trafficking in. It's a little bit different situation, and the final problem with domestic workers is just maternity leave. I know that they have the right for 10 weeks of maternity leave according to the legislation. But in certain situations there is some contradiction with the rules of live-in and 2 weeks rule as well. So from that point of view, I'll be very pleased if you can explain how it is conciliate this contradiction between 2 different rules: the rules, the right to the maternity leave, and rules of live-in and 2 weeks. Because sometimes they giving birth just on the verge of their living country, and so from that point of view, it's very important to understand. In Macau, the situation is a little bit different. Fortunately, there is a law 6 of 2008 on combating trafficking in persons. I'm finishing just to finish my sentence, and that's all. Anyway, I'll be very pleased if you may explain if you are planning to ratify ILO Convention on decent work of domestic workers. It's Convention of ILO number 189. Thank you very much.
Je m'excuse, Mr. Avtonomov.
I apologize, Mr. Avtonomov. Madam Mohammed, you have the floor now. Thank you, Chairman. I would like to welcome the delegation of China and my colleague, Mr. Marogan, for his very detailed report. In June 2017, the government of China adopted a series of restrictive laws targeting religious practices and the Muslim religion above all. And this has led to the arbitrary and mass detention of almost 1 million Uyghurs, which I hope I'm pronouncing correctly. My question is as follows. What is the level of religious freedom available to Uyghurs now in China? What legal protection exists for them to practice their religion? And I have a question on domestic workers, which was already referred to by Mr. Abtamanov, but I won't repeat what he said. I would just like to add that according to the information I have received, domestic workers, those who reside with their employers, notably in Hong Kong, cannot end their contracts and their passports are often confiscated. So I'd like to hear about that. Thank you.
Madame, merci.
Thank you, Madame. So, Madame Chang, you have the floor.
Thank you, Chairperson. Actually, my presentation is very exactly same with Rita's one, but because you gave the floor to me, I'd like to emphasize this issue again. This is the DPRK defector issue. Because North Korea, DPRK is bordered with China, the people who escape from North Korea should enter China anyway for entering South Korea or any other third countries. Because of the economic and political deterioration of the North Korea, every year a huge number of people try to go out from DPRK. September 29, 2003, UNHCR pronounced that North Korea, DPRK defectors can be considered as mandate refugee, even though it is a regular refugee status, who should be protected by the United Nations. This issue was also discussed by Human Rights Council and also U.S. government in 2012. But there are many reports that the DPRK defectors suffered from trafficking, sexual and labor exploitation, and violence in China. And more tragic thing is the Chinese government detained them and send back them to DPRK, where they are severely persecuted. The number is huge, even though there is accurate statistics. U.S. Department of State in 2005, there were 75,000 to 125,000 North Korean defectors in China. An international crisis group estimated in 2006 there are 100,000 people in China. U.S. Committee on Refugee and Immigrant, USCRI, reported among them 5,000 were sent to North Korea in 2005 and 1,800 in 2007 and 1,000 in 2008 in China. South Korean NGO, Association for Democratization of DPRK, estimated in 2009 that 200,000 to 300,000 DPRK defectors resided in China. Among them, 70,000 to 100,000 were sent back to North Korea. DPRK government itself submitted the information to CEDAW in 2017 that during 2005 to 2016, 6,473 women returned to DPRK. So it would be very much appreciated the Chinese government make survey on this situation and then provide us the accurate statistics and information on the situation. Thank you very much.
C'est moi qui vous remercie, Madame.
Thank you, Madam Chung. I would now like to give the floor to Ms. Shepherd, who will be followed by Ms. McDougall. In the next 15 to 20 minutes, to then allow the head of the delegation to take the floor for a few moments before 6 p.m. Ms. Shepherd, you have the floor.
Thank you very much, Chair. Thank you for your generosity. Let me continue now with the issue of education, and I turn now to the Uyghurs. We have complaints that China's bilingual education program has nearly eliminated the use of Uyghur as a medium of teaching and replaced it with Chinese language teaching. That Hotan Prefecture passed a ban on the use of the Uyghur language at all education levels in July 2017. So could the State Party verify these reports as well as explain how the government is supporting minority language rights of the Uyghur, especially given the protection in the Constitution and in the regional ethnic autonomy laws? With respect to Macau, China-Macau, I would remind all of us that, of course, after over 400 years of Portuguese colonialism, Macau's status is now that of a special administrative region of the People's Republic of China. In such a situation, the issue of written and spoken languages becomes a matter of concern. The three official written languages are English, Portuguese, and Chinese, and the four spoken languages are Chinese Cantonese, Chinese Potongua, and Portuguese and English. But the colonial history and the language policies of a post-colonial reality pose challenges. So, two questions on this. What is the government policy to ensure ethnic minority students who use Potongua to learn Chinese have a chance to learn Cantonese, the mainstream language in the community, to facilitate social integration? And how will the State Party enhance students' communicative competence to meet the needs of what appears to be an economic boom? Turning now to the issue of Tibet. Article 4 of China's constitution states the following: all nationalities have the freedom to use and develop their written languages, end of quote. However, we have received information that the preservation of Tibetan language and culture is under threat as the government has pursued aggressive measures such as the so-called bilingual education system and the inland Tibetan classes to embed a uniform national identity and to promote the use of Mandarin Chinese among Tibetans. The authorities justify these measures in the pursuit of unification of the country and unity of all its nationalities. Reports indicate that Tibetan language teaching in schools in the region has been significantly restricted, that Tibetan language advocacy has been punished, and that Tibetans do not have access to Tibetan language translations during court proceedings which are held in Mandarin. So Mandarin appears to be the language of public engagement, despite the existence of a number of minority languages and the commitment of the state to respect such languages. the main concern then is the attitude and policies towards the use of the Tibetan language as a medium of instruction in schools and other public institutions. And over the years, there appears to have been either collective or individual protests among Tibetans in support of using the Tibetan language in schools and public life. And these protests in support of their language rights allegedly have been met with repressive measures. And we have been told of the case of Tashi Wangchong, a businessman and shopkeeper who was imprisoned in January 2016 following the release of a New York Times video profiling his efforts to request additional Tibetan language classes at schools in his home area of Yushul in Gwinjai. Now, so a few questions arise from that. What prevents the state party from actively promoting the Tibetan language and including Tibetans in drafting and implementing language-related policies? And I suppose when regional courts fail to use the Tibetan language, are they not contravening the Chinese constitution? And how would you comment on a state media report from 2018, which states that students have at least one class every day in Tibetan? And would you consider one class as sufficient to justify the Tibetan language in schools and the larger public? So I guess in sum, the larger question is, how does the Chinese government ensure that the laudable bilingual education system provides Tibetans, Uyghurs, and other ethnic minorities with adequate opportunities to learn their own language and does not lead to bans on the use and instruction of ethnic languages? And finally, Chair, Head of Delegation, if I could just pose two more questions on the issue of Hong Kong, because the government claims that parental choice is the cause to de facto segregation. But there's a study done by one Hong Kong NGO which shows that it is not a priority of ethnic minority parents to put their children into schools with a high percentage of non-Chinese speaking students. So can we get an explanation of why de facto racial segregation still exists in the public school system, despite removing the label of designated schools since 2013-2014? And what are the measures to desegregate schools which have high concentrations of ethnic minorities in the student population and to foster real integration? Finally, what is the content of history education? And in terms of the simplified curriculum, which I suppose is facilitating those who are not Chinese language speakers fluently. That examination is a British GCSE. Is this supposed to be a short-term measure, or what is the timeline for shifting from that curriculum? Thank you very much, Chair, Head of Delegation.
Merci, Madame.
Thank you. Thank you for that statement. I would now like to give the floor to Ms. McDougall. And perhaps also allow the delegation to take the floor in 10 minutes' time. That is at about 5:45. Thank you very much, Ms. McDougall.
Thank you, Chair, for letting me continue, because I want to come back to this issue of the detention camps and the re-education camps in the Uyghur Autonomous Region, and just ask a clear question. I really would like to invite the state party to respond to the many reports about the millions of people who have been detained in this region. I would ask you to please disclose details on what grounds people are sent to the so-called re-education camps. What due process rights are they afforded? Can you give me the laws that, or copies of the laws that those detentions are based on? Are there police reports about their offenses when they were, picked up by the police? And can you give us copies of any of those documents that might give us a sense of why these camps were created, for what purpose, and what indeed happens when someone is put into these re-education camps? Another question I want to ask is about the policy that was passed in 2017, although it seems to have been operative maybe before, that call for Uyghur students to come back. I would like for you to tell us what are the current circumstances of the Uyghur students who may have returned voluntarily to be cooperative or were forcibly returned to China in the period in the since I think maybe 2012. In particular, those who were returned from Egypt and Turkey in 2017, from Thailand in 2015, and from Cambodia and Malaysia in 2012. I've seen reports that that upwards of 100 of them were disappeared, that some were detained, that some were died in detention. So if you could actually give us some details about all of those students who returned. And finally, I want to ask a question about the treatment of Uyghurs in Hong Kong and the application of the unified screening mechanism. I want to ask our Hong Kong authorities here to please respond. Will the Hong Kong authorities consider non-refoulement claims made by individuals from Xinjiang and Tibet or other parts of China who find themselves in Hong Kong and are at risk of torture or other forms of cruel and inhumane treatment if they are returned to the mainland? So the question is the unified screening mechanism that really is put in place to observe the non-refoulement rights of people returning. You apply that to the Uyghurs as well? Thank you.
Merci de votre coopération.
Thank you for your cooperation, Ms. McDougall. I would now like to give the floor to the head of the delegation, His Excellency the Ambassador, for the remaining 15 minutes. I would ask him to take the floor and share with us his initial impressions before, of course, answering the questions raised by the members of this committee, and that includes, of course, the rapporteurs. I give you the floor, Mr. Ambassador. You have the floor, sir.
主席先生、各位委员，今天下午我们认真听取了各位委员的意见。
We have listened carefully the members' views of the members. The members, since the last review in 2009, commented on the active, positive progress achieved since then to which we express our appreciation. At the same time, the members have, from their own perspectives and aspects, raised their questions and raised certain points on which they require us to provide further information and data. We have taken careful notes of this. The central government in China and the SAR governments of Hong Kong and Macau and their representatives will follow the provisions of the convention and the requirements of the review to deal and classify the questions and views and prepare our responses. We will respond to the main questions on the morning of Monday next week. We firmly believe that, with efforts of all parties, the review will achieve its expected purpose and will be a complete success. I thank the chairman and the distinguished members very much. I'll see you next Monday.
Bien.
Fine. So with those points from the head of the delegation, His Excellency the Ambassador, with those words we will now complete our work for today, and we will meet again on Monday of next week at 10 a.m. In the meantime, over the weekend, we expect the delegation will have to do a lot of work and prepare answers to the questions, which is no easy matter. So, again, I look forward to seeing you all on Monday at 10 a.m.